Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Flass, two other attorneys from Idaho Employment Lawyers, and we're talking about work phones, personal phones, cell phones, and all the interesting nuances that go with that issue. So really, if you're an employer and you have employees using phones for the scope and course of their duties at your place of employment, do you need to give them a work issued phone or can they just use their personal phone? There's a lot of issues you should think when you are noodling through that question. And that's what we want to talk about today. It's kind of a fun issue. We have seen in a number of cases how that issue can come up, and we want to share that with you today to give you some ideas and some thoughts on whether or not you need to take the time and the money and make the investment in issuing work issued cell phones. So I'm going to kick it off and have Doug kind of talk about some wage and hour issues that go along with that. When we were brainstorming the key issues we wanted to raise with the audience, Doug had some wage and hour issues. And I have to say, those had not even crossed my mind. So Doug has become somewhat of our in-house wage and hour expert. And those are important issues. And if you're like me, maybe those don't even immediately pop up when you're thinking about whether or not you need to issue work phones or whether employees can continue to use their own personal phones. So Doug, tell us a little bit about that, because I will also say Doug wrote out a list and wage and hour was at the top of his list, which makes me think it was the first one that came to mind for him. So tell us why wage and hour issues came to the top of your list.
Well, so a lot of times, what we see is, the most common thing is that, employees have access to their work email potentially on their personal device. And, employers need to think about, especially when we're dealing with non-exempt employees, so your employees that are generally paid at an hourly rate, if they're doing any work outside of the normal workday, they need to be compensated for that work. So if you are sending an email, you might not think anything about sending an email at 9 o'clock at night, but your employee might get that email at 9 o'clock at night because it's on their personal phone, and then they read it or answer it or whatever, and the employer is obligated to pay them for that time. And if it's on a personal phone, how do you know when they're working, when they're not working? That can be a real big issue. And then another issue that occurs is with exempt employees. Now, if you have an exempt employee that is on a paid day off, so they're not working on that day, and then you send them an email and they receive an answer and they work for 1 minute, well, most of the time you're going to have to pay them for that full day. And that's not something employers generally want to do.
I'll jump in.
Yeah.
That one comes up if somebody's on some type of leave, right? Specifically, if you have an exempt employee, maybe they're on FMLA leave or something, where they're not necessarily getting pay. If they do start checking messages on their phone, you may have some kind of entitlement to pay them where you otherwise wouldn't. That's the one where I see that come up.
Yeah, and if you've issued a work phone, you could instruct them to please have that off. You can't really tell people to turn off their own personal cell phone. So your ability to control when the employee is working, and thus control when you have to compensate them for is severely lessened if they're using their own personal device.
Yeah. And I'll throw out there, we've seen somewhat of an uptick in wage and hour activity in 2025. I feel like in some years there's more wage and hour issues and lawsuits and DOL activity going on than in other years. And this year we're seeing some interesting wage and hour lawsuits, interesting wage and hour questions. So if you're not giving much time and attention to wage and hour, you definitely should, because they're complicated. difficult to resolve, a lot of issues that go along with those. So one more nuance to the whole wage and hour piece, thinking through timekeeping and people checking messages when they're not, maybe when you don't think they would be otherwise.
And we've seen cases where, you know, the employer maybe didn't keep very good records, and the employee is coming back and saying, "Here, I worked, I worked from this amount this time in the morning until this time at night. See, here's my first message with you, and here's my last message with you." And the employer in that situation is really at a severe disadvantage because the presumption, if there isn't good record keeping on the employer's part, is that whatever the employee says is true. So,
Probably another podcast episode, the whole record keeping requirement for employers to be thinking about all those nuances that go with wage and hour work. Hopefully, if you're listening to this, you know that if you've got non-exempt employees, you better be keeping good records. You'd be surprised. A lot of employers don't realize that. That is a very, very important issue. So let's move on to another one that I think is fun to talk about. Jennifer, I think, might agree because we've spent a lot of time over the last few years talking about some data security issues, trade secret issues, confidentiality issues, a lot of those type of issues that go along with an employee using a personal phone when you've got certain types of information being saved or transmitted on that personal phone. So, Jennifer, jump in. What comes to your mind when you think of that?
Well, the first thing that came to mind is just how often this comes up in our practice. I really can't can't tell everyone how many times we get a call from someone who says, "Hi, I have an employee who just left. They went to work for, a competitor, and I think they have a bunch of my information they shouldn't have. What can I do?" And there are things you can do in that situation, but what often shakes out is that that employee does have some amount of information they took with them, but there weren't really very good safeguards in place to prevent that employee from taking that information when they left. And sometimes that does include that, that it was on a phone that was their personal phone. And so they walked away with, all their sales contacts or with some documents that they had saved on their phone. And if you as the employer didn't have a requirement of using a work phone or didn't have security on the phones or take steps before their departure to remove information from the phone, that just can lead you into a difficult situation. So kind of stepping back a little bit, I mean, one thing is if you as the employer are going to say, "I have a category of information that is important, it's confidential, it's proprietary, maybe it's even a trade secret under state law." I mean, Idaho, here we have an Idaho Trade Secrets Act that lays out certain information that may qualify as a trade secret and be entitled to additional protections under state law. And if you as an employer are going to say such things, it is helpful and important to be able to say that you took meaningful steps to protect that information. And that may include things like having a confidentiality policy in your handbook that lays out what information you consider to be protected and telling employees that they are expected to not disclose that information or take it with them when they leave. And when they leave, they're supposed to return it to the employer and give it back. It might be an agreement with the employee, like a non-disclosure agreement or confidentiality agreement. And then on top of that, sort of these technical tools, right? So one of them may be using work computers, right? Just issuing employer provided devices to your employees to use at work so that when they leave, those devices get returned. And that will really help to ensure that information isn't taken. If you have a more robust IT department, you might even be able to set up additional protections like passwords for logins, maybe, prohibiting employees from using USB devices on their computers. There's all manner of, kind of tech specific protections that employers also can use if they want that level of protection. So that's kind of one thing I was thinking about, is the departing employee. But really on top of that too, just to protect from, loss or theft of a device, right? If you have an employee who may be traveling for work, they lose their phone or someone, filches it out of their off the countertop or out of their purse or something while they're traveling. You want to make sure that whoever gets that device, can't get into it and get your information. So also just making sure there are adequate, password or other protections on the devices also is helpful from a data security perspective.
Yeah, that was a lot because and there are a lot of little sub issues that go along with that. A couple of thoughts I had as you were talking. What Jennifer's saying really reminded me of all the different types of information that might be held on a phone, right? That it might involve. Like you could be talking about your contacts, who is saved in the contacts. You could be talking about text messages being transmitted. Do you have a salesperson texting another salesperson? Here's an example that we've had come up. Do you have two employees, one who's left, soliciting another one to come with them? Something like that could be important. And then emails, right? And there could be phone messages and there could be photos. Like there's a lot of stuff that could be evidence on a phone that comes up in a whole host of scenarios that we encounter. The situation Jennifer was talking about, I feel like if you have an organization or a company where you have salespeople, you definitely need to be thinking through this issue because we, at least several times a year, this situation comes up where we get calls from employers who have salespeople. A salesperson leaves. The employer maintains that the client list is confidential, proprietary, possibly trade secret, and they're worried that the employee has taken that with them and that they're going to jeopardize their place in the market. For us, if we get that call, one of the first questions is, are they saving that on their personal phone? Like, where are these contacts? Because if you're letting your salespeople save client contacts on their personal phone, that's going to make it tougher for you to argue that that's really important information for your company, because by letting them use it on their personal phone, you're giving them unfettered access to it, and that may send the signal that that's not confidential, proprietary, trade secret info. So in the sales context, I think it's very, very important. A couple other thoughts I was having was we see issues related to phones come up a lot when we're talking about evidence in our employment law cases. Text messages now are very common types of evidence that both parties may well rely upon.
Yeah, I was trying to think about a case where text messages weren't at issue, and I can't come up with one. Yeah. Every single case.
Yeah, it is really the new norm. And for us, I think that's terrifying because it's really hard to get a hold of them. If someone refuses to produce them, if someone throws their phone away, if someone deletes the text, it makes it really hard to compel someone to produce it. And I think when this first started to come about, maybe like, a couple decades ago, I guess, I think the thought was, well, maybe you just go to the carrier and like subpoena the text messages. Very difficult. And we've had very little success. And there may be a way to do it. If there is, and you're listening to this and you're a litigator, please give us a call and let us know what that is, because we have a lot of trouble getting a hold of text messages on someone's personal phone. And if that's your key evidence, that's a problem, a huge problem. So, here's a scenario of where that might come up. Say that you have a supervisor who uses their personal cell phone to stay in contact with the people they supervise. Maybe someone's having performance issues, and I feel like where it comes up all the time is someone's late. Hey, I'm going to be late today. I've got a crisis at home, or hey, I'm sick. I'm not going to be able to make it in. If you've got a supervisor contacting people about performance problems and that's what they're relying on to document it, well, if the supervisor is using their personal phone and they walk out the door, no longer employed with you, and the employee subsequently brings a lawsuit, you may not have access to what really is the best info in the case. So that's just like one example of how that comes up, but a very easy, I guess, easy for us to say. I know it's not exactly easy for an employer to implement, but one workaround is to make sure they're using their work issued phone. And then when they leave, you've got the work issued phone. So I think that is an important issue too. I'm trying to think through other cases where this has come up. So, we definitely have trade secret cases. We definitely have confidentiality breach cases. We definitely have fiduciary breach cases. We definitely have discrimination cases where that's your legitimate, non-discriminatory reason showing there was a performance issue. Wage and hour cases. I mean, IPPEA, we do a fair amount of public entity representation. And so whistleblower type cases, that's what our Idaho one is called, the Idaho Protection of Public Employees Act. It could be some kind of evidence in a whistleblower case. It could come up really in any of those scenarios. So this is a big deal for employers. If you've ever heard us, really train supervisors, we're always talking about documentation and the fundamental role it plays in making sure as a supervisor or as a business with supervisors that you've got your bases covered. This is just one more type of documentation you need to be thinking about. So Jennifer, did you touch on, I don't think you did, like the example you were giving about how if an employer were to let someone use their personal phone, how they should have like an offboarding protocol to make sure that they take safeguards to get that info.
Yeah, and no, I didn't touch on that. I think it can be difficult if you have employees who are allowed to use their personal phones, but I think employers, if it's not in the cards for whatever reason to have work issued devices, kind of the next best thing I think would be to have in your policies, maybe in other documentation that the employee acknowledges that there will be an offboarding process if and when they leave employment with you, and essentially sit down with them and figure out like what information is on the phone that needs to be, maybe, removed from the phone, but potentially also, retained in some fashion. It's saved for the employer's records as well before this person departs. And, like I say, with contacts, that can be a tricky process sometimes, but especially if the departure is, more amicable, I'm sure you can work through it with the employee. If the departure is a little bit less amicable, that's where, it really can get challenging, right? Because the employee might refuse to give you the phone, but, kind of as an employer, still got to try and see if you can find a way to get your information back. Also, too, there might be ways to, depending on how your IT setup is, that you could cut off cloud-based or linked access to work. Like I think, for example, I'm not an IT person, but I think if you have access to your work email on your personal phone, there are ways for the employer to shut off access to that link through their own system. So you'd want to do things like that as well, right? Kind of as a matter of protocol to make sure to the extent that you are able to cut off any access the employee has via their personal phone, to do that as a matter of your routine offboarding. And then if you know or suspect the person has, kind of locally saved information, that's when you may have to actually, say, let's sit down, let's look at it, let's figure out what you can take and what has to stay here.
Yeah. So tell us a little bit, like walk us through what that kind of looked like when you were talking about having a previous employer where they did that. Like,
Oh, yeah, I guess I was giving an example for a former large law firm where I worked. And at the time, I did have a personal phone that I was allowed to use and had access to, my work email. And, I think I could be able to check my voicemail and things like that, like from my personal phone, like call forwarding essentially to my personal cell phone. So those things were removed, and I don't know exactly what it was, but there was some software that was put on my phone by the employer that kind of coordinated those things on my personal phone. And when I was leaving, the IT person came in and sat down and took my phone for, a minute or something. They did what they had to do to kind of remove the work related information and verify that it had been removed from my phone and get the phone back. And that was it. So, I don't know the technical specifics of what they were doing, but they had a protocol in place that they used and basically had thought through it in advance, right? Like, if we're going to do this for people, let them have their personal phones. How are we going to manage our information, make sure it's secure? I was saying, we also had additional, like, specific requirements for data security. So the way we logged into our phone, I've it's been a while, but I remember, I think, having, kind of, I think it was RFID, RF, the random password generator type stuff, where we had to use that on occasion to log into certain things, right? Just to kind of verify that we were who we were supposed to be. We are entitled to access to certain information. So they had things like that in place that were designed to help safeguard the information. And as a law firm, too, it's especially important, right? Client information and everything. So it was particularly important as lawyers that be the case.
yeah, that's a good point with the passwords too. Like, if you were letting employees use their personal phones, for sure, you'd want to have that password mechanism because, as we were talking about earlier, if you want to show something truly is a trade secret under Idaho law, you need to show that you took reasonable measures to protect secrecy. That's one reason you do it. A password is one way you're taking reasonable measures. And then again, like in the law in particular, if you've got emails, for example, that might have some type of confidential client info that an employee has on their phone, you would definitely want safeguards to make sure that if that phone gets lost or stolen, that someone's not going to be able to open it up and access that information. So, Doug, talk a little bit about reimbursement, like what your thoughts are on that insofar as how that relates to this discussion.
Yeah, so we're here in Idaho, and it's not this way here, but in some states, there are laws that require, and I think I'm thinking particularly about California. There are laws that require that employees be reimbursed for business expenses for those things that are required for work. Now, if you need your employees to use their personal cell phone for work, you might want to consider reimbursing them for that. And if you're going to reimburse them for that, why not get your own employer issued cell phone? That's kind of where I come out on that. Like, do you really need them? These days, it used to be everybody had a landline, right? If you wanted to get a hold of an employee outside of work, you'd call them at home. That's not the case anymore. In fact, most people, I think, don't have landlines anymore, and we all have cell phones. And we all kind of need to be able to get a hold of people on their cell phones. And if that's part of your job, um, you might want to consider paying for it, and you really might want to consider just having your own employer issue cell phone so that you can control what's going on there for the reasons that Jennifer's just been talking about. When Jennifer was talking, I thought about all the great systems that her previous employer had for dealing with this, and contrast that with what we see, which is, oh gosh, I let this employee go, and now I'm thinking about it for the first time, and now we're going to ask this employee to let us have access to their phone without giving them the heads up that this is coming at all. And how many employees do you think are going to say yes? I'm going to guess that's in the single digit percentage wise.
Yeah, as Doug was talking about, we've talked a lot about different ways that you can protect information. Some of these are they're technology solutions that, may well require a IT professional to help you implement them. But at least if you're thinking about it in advance, you can decide if that makes sense for your workplace and what that might look like. But there also are some things that you can do that don't require an IT professional, and that would be things like your policies or agreements that really lay out your expectations for how employees are going to handle the information in the workplace, what kinds of information is considered to be particularly sensitive or confidential. So there are other tools that you can use as well, even if you aren't in a position where you can have sort of all the IT bells and whistles. Although to the extent you can have some basic protections like password protections, that I think that'd be a good idea. And probably easier to do these days than it might have been, 10, 15 years ago.
And a good reminder by Doug, right? Like, as to all things employment law, if you have employees in other states, there could be other considerations. We're in Idaho. We don't have a lot of regulation when it comes to that. But if you've got an employee in Washington, Oregon, New York, I don't know. Maybe there are other things you should be thinking about in terms of cell phone usage if you're letting employees use their own phone. So, what I heard everyone talking about is a whole host of issues, and you hear us talk about the importance of having good policies and protocols, and a couple that we talked about today that came up here, maybe good time to check your handbook and see if you've got some of these in there. Doug was talking about wage and hour. Like, do you have a good wage and hour policy? Do you have that no off the clock work policy unless it's being entered as time worked? So check the wage and hour policy, confidentiality, what you maintain as proprietary confidential info, a tech policy. You may have access to our phone, but or a company issued phone, but it's still our info, or a whole host of other tech related concerns. Think about your confidentiality agreement you're going to have everyone sign. Maybe have everybody sign an NDA confidentiality agreement. Maybe you want this type of info addressed in there. And then think about your onboarding and offboarding policies. If you terminate someone, do you need to be thinking about, wow, do they have some type of confidential info saved on their phone that is info belonging to the company? And if so, how do we go about getting that from them? And if you're going to do that at offboarding, hopefully you're letting people know when you're onboarding them that that's the expectation there. So that's it for today on ground rules, employment law over your coffee break. I hope you got some good takeaways and practice pointers from that. Don't forget, we've got our Law for Leaders book, the roadmap every leader needs to know to avoid workplace claims and lawsuits. And our own Doug Plass wrote chapter 15, which is about keeping your information safe. So that ties right into what we're talking about today. We have our Law for Leaders recorded content. We do live content. We do have a session of our recorded content that talks about confidential trade secret info. And then we love to come into the workplace and reinforce some of those concepts and help, kind of get a live conversation going. On top of that, we've got a training coming up in September. We're doing one on workplace investigations. So if you do workplace investigations, or you think you might need to do workplace investigations and you want to make sure you've got the basic protocol down that's going to help make that a really solid, reliable, compliant investigation, come check out our training. It's I think it's September 18th, mid-September, September 25th, September 25th. So we'll be sending more information out about that. Keep an eye out for that. And otherwise, we'll see you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.